ATF loses in court again, and at this point that phrase is starting to sound familiar. A federal court has once more ruled against the Bureau of Alcohol, Tobacco, Firearms, and Explosives, dealing another setback to the agency's attempt to enforce a firearms regulation. And while the specific details of each case may differ, the broader pattern is becoming harder to ignore. So today, we're not just talking about one ruling. We're talking about what it means when the ATF keeps losing in court, why these losses are happening more frequently, and what this trend signals for gun owners, regulators, and the future of federal firearms enforcement. Because this is not just about a single case, it's about a shift. When the ATF loses in court, the immediate reaction is usually split. Some see it as a clear win for gun owners, others assume it's temporary and will be reversed on appeal, and some dismiss it entirely, believing nothing really changes. The truth sits somewhere in the middle. Each loss may not end a regulation permanently, but together they reveal something much bigger. They show how the legal landscape around gun laws has changed, how courts are responding differently to agency power, and why the ATF is finding itself on increasingly shaky ground. To understand what this means, we need to step back and look at how the ATF has historically operated. For decades, the ATF has relied heavily on administrative authority. Congress would pass broad statutes, and the agency would fill in the details through regulations, guidance documents, and enforcement policies. Courts generally deferred to agencies under doctrines that allowed regulators wide latitude in interpreting ambiguous laws. That deference gave agencies like the ATF significant power. They could redefine terms, expand enforcement priorities, and apply new interpretations without Congress passing a new law. But that environment has changed. Over the last several years, courts have become far more skeptical of agency authority, especially when it affects constitutional rights. And nowhere is that skepticism more pronounced than in cases involving the Second Amendment. When the ATF loses in court today, it's often because judges are no longer willing to accept broad agency interpretations at face value. Courts are asking harder questions. They are demanding clearer statutory authority, and they are increasingly unwilling to let agencies create new rules that carry criminal penalties without explicit congressional approval. This shift didn't happen overnight. It's the result of a series of Supreme Court decisions that have reshaped administrative law and constitutional analysis. One of the most important is the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen. Bruen fundamentally changed how courts evaluate gun regulations. Instead of balancing tests or interest-based analysis, courts must now apply a historical framework. Judges must ask whether a modern regulation is consistent with the nation's historical tradition of firearm regulation. That standard has proven difficult for governments to meet. Many modern gun regulations are relatively new. They do not have clear analogs from the founding era or early American history. And when agencies like the ATF attempt to regulate firearms through administrative rules rather than legislation, that historical problem becomes even more pronounced. Courts are now asking not just whether the ATF has authority, but whether that authority can survive constitutional scrutiny under Bruen. And in many cases, the answer has been no. Another factor driving these losses is the growing resistance to what courts view as agency overreach. Judges are increasingly concerned about agencies effectively creating new crimes through regulation. When the ATF issues a rule that redefines what constitutes a firearm, or who qualifies as a dealer, or what conduct is prohibited, the consequences are serious. Violations can carry felony penalties, prison time, loss of rights. Courts are wary of allowing an executive agency to wield that kind of power without clear direction from Congress. This is where the so-called major questions doctrine comes into play. Under this principle, courts require clear congressional authorization when an agency claims the power to decide issues of vast economic or political significance. Firearms regulation unquestionably falls into that category. When the ATF loses in court, it's often because judges conclude that Congress did not clearly authorize the agency to do what it attempted. In other words, the agency went too far. These rulings don't just affect the specific regulation at issue. They send a signal. They tell the ATF that courts are no longer willing to rubber stamp expansive interpretations. They tell other agencies that the era of unchecked administrative power is fading. And they tell regulated communities, including gun owners and businesses, that the legal environment is shifting. But what does this actually mean on the ground? First, it means enforcement uncertainty. When a court blocks or overturns an ATF rule, enforcement often pauses. Investigations may slow, prosecutions may be delayed or reconsidered. Businesses and individuals are left trying to determine what rules still apply and which ones are in legal limbo. That uncertainty cuts both ways. It limits the ATF's ability to act decisively, but it also creates confusion for regulated parties who want to comply with the law. Second, it means appeals are almost guaranteed. The ATF, often backed by the Department of Justice, rarely accepts these losses quietly. Appeals are filed, emergency stays are requested, cases move to appellate courts, where outcomes can vary. Sometimes injunctions are lifted, sometimes they remain in place, and sometimes appellate courts issue narrow rulings that leave key questions unresolved. This prolonged litigation process is becoming the norm. Third, it means Congress is being forced back into the conversation. When courts repeatedly reject agency rules, the pressure shifts to lawmakers. If Congress wants certain regulations to exist, it must write them into law clearly and explicitly. That is not easy in a divided political environment. As a result, many regulatory goals stall, not because they lack support, but because the path to achieving them has narrowed. For gun owners, this trend has both benefits and risks. On the one hand, repeated ATF losses reinforce the idea that agencies cannot unilaterally expand gun regulations. That provides a measure of protection against sudden rule changes that carry criminal penalties. On the other hand, legal uncertainty can be dangerous. Relying on a court ruling that may be stayed or reversed is risky. Enforcement policies can change quickly, and what is lawful today may be contested tomorrow. That's why responsible analysis emphasizes caution rather than celebration. Each ATF loss matters, but none of them exist in isolation. Another important point often overlooked is how these cases shape future enforcement strategies. When the ATF loses in court, it doesn't just move on. The agency studies the ruling, it adjusts its arguments, it revises its approach. Sometimes that leads to narrower rules, sometimes it leads to new guidance documents, and sometimes it leads to entirely new strategies that attempt to achieve the same goal through different means. This cat-and-mouse dynamic is part of regulatory law. Courts push back, agencies adapt, new cases arise. What's different now is the direction of travel. For years, the trend favored agencies. Deference doctrines gave regulators the benefit of the doubt. Courts were reluctant to interfere. Today, the momentum has shifted. Judges are more assertive. Constitutional scrutiny is stricter, and agencies are losing more often. This doesn't mean the ATF is powerless. It still enforces existing statutes. It still conducts investigations. It still plays a major role in firearms regulation. But it does mean its room to maneuver has narrowed, and that has long-term implications. One of those implications is consistency. When agencies lose authority to reinterpret laws, enforcement becomes more predictable. Clear statutes replace shifting regulatory interpretations. That predictability benefits everyone, even regulators, by reducing litigation and uncertainty. Another implication is accountability. When Congress must act directly, voters know where responsibility lies. Regulations passed through legislation are subject to debate, amendment, and repeal. They are harder to change quietly. That transparency is part of the constitutional design. At the same time, the current environment increases the stakes of each court case. With fewer regulatory shortcuts available, each legal battle becomes more consequential. That's why ATF losses in court draw so much attention. They're not just setbacks, they're markers of a larger transformation. So what should people watch for next? First, appellate outcomes. District court losses are important, but appellate courts often set broader precedent. How circuit courts handle these cases will shape national enforcement. Second, Supreme Court signals. Even when the court declines to hear a case, its orders and dissents can reveal how justices view agency power and gun regulation. Third, legislative responses. If Congress moves to clarify or expand firearm statutes, that will reshape the battlefield entirely. And finally, enforcement behavior. Agencies adjust in real time. Watching how the ATF enforces existing laws can tell you as much as any court ruling. So when you hear that the ATF has lost in court again, don't just focus on the headline. Ask what it reveals about the broader trend. Ask how courts are framing their decisions. Ask whether this ruling limits agency power or simply delays enforcement. And most importantly, ask what comes next. Because the story here isn't about one case or one rule, it's about a system recalibrating. A system where agencies are no longer assumed to be right. A system where constitutional limits matter again. And a system where the balance of power between Congress, courts, and regulators is being actively renegotiated. That process is messy, it's slow, and it's far from over. But one thing is clear. When the ATF keeps losing in court, it's not an accident, it's a signal. And understanding that signal is far more important than celebrating any single win. Because the real question isn't whether the ATF lost again, it's what that loss means for the future of gun law in the United States.